Good afternoon, everyone. This is Pat Harvey along with Erin Clark and Alex Bak-Boychuk, and we are discussing today how to manage work-related injuries and the global interaction of workers' compensation, the ADA, and maximum leave policies. All three of the attorneys on our panel are labor and employment attorneys with a lot of experience involved in disability issues, and I have the most gray hair on the panel. I have two younger panelists, and I'm the most elder panelist here. And just from my experience in handling the labor and employment issues involving work-related injuries, I bring a little bit of a different background than our other two panelists. For one part of my illustrious legal career, I ran a workers' comp defense practice for about 10 years. So I've seen this from every angle, and we all want to discuss some of those angles today on how some of our clients outsource to various degrees the handling of workers' comp injury claims. And when you do that, how you can run into certain problems if your outsourcing goes too far. And one of the messages we want to put across here today is you have to manage these issues globally, and you cannot totally outsource these issues at all, especially when we're dealing with the ADA issues for our employees who suffer work-related injuries. So we're going to start off by talking about the general issues, and we've broken down these issues into some of the questions we get asked most often. So let's start off by making the general point, if we can, that many employers too often suffer sort of a tunnel vision when they look at workers' compensation injuries, and they do not fully globally manage these claims in conformance with, when you're talking about workers' comp injuries, you also have to examine whether your injured worker falls under the category of a disability under the ADA, managing not only your workers' comp issues, but your ADA issues, of course, looking at your labor contracts and your leave policies, managing all these issues together. And then this global management is not only essential in limiting your liability under all employment laws, under the workers' compensation statutes applicable to your state, but also in just managing your workforce and getting people hopefully back to work in a reasonable time period. Okay, so when we talk about, and we're going to talk about also here today about necessary policies and procedures for globally managing your employees who suffer work-related injuries, and also discuss in the most frequently asked questions we receive from clients, and then we're going to conclude after going through these questions and obviously answering these questions, we're going to conclude with recommended policies and practices for globally managing all of your work-related injury issues. All right, so here's the questions we're going to go through today, and we're going to break these up. Our panelists are we're going to break up these questions. But the first question, and we're going to start off at the beginning. When you hire someone, can you screen out employees? Can you ask applicants about his or her workers' compensation injury history in order to hopefully screen out what you believe are candidates who've had a lot of sort of a tortured workers' compensation history? And I have the gray hair on the panel. I remember when this question used to show up on employment applications years ago, and you're going to find out that I'm not going to steal the thunder of the person answering that question, but you're going to find out that maybe that shouldn't show up anymore. Question number 2, will a resignation letter accompanying a workers' compensation settlement shield an employer from employment liability? A lot of our clients, when they refer or they outsource too much of the handling of a disability claim, will hear from a workers' comp attorney who's handling this injury claim for you, and the workers' compensation attorney will say, good news, I got a resignation letter for you. We managed to bump up the settlement a little little bit, but I got you a resignation letter. All your worries are over. Well, we're going to discuss in this question, are your worries over? Is a resignation letter the same as an employment release? Question number 3, if my insurance company or third-party administrator or workers' compensation adjuster is handling all of my workers' compensation claims, do I have to worry about the ADA? Do I have to worry about the reasonable accommodation process if I outsource everything to my insurance company? We're going to find out, and I don't want to steal the thunder of this answer, but you should never totally outsource this. You have to manage this. Number 4, the 4th question we're going to address is, how long, and this is the question that haunts all of our clients, how long do I have to keep an injured worker on the employment rolls? Is there a magic number? Is there a bright line? Is there an exact month? Is it 6 months, 8 months, 9 months, a year? And if I have a maximum leave policy, is it legal? How's the EEOC going to look at my maximum leave policy when we talk about the ADA issues involved with work-related injuries? So we're going to drill down and talk about maximum leave policies and how long you do have to keep injured workers on the employment rolls. Question number 5, should I designate workers' compensation leave as FMLA time? When we have an injured worker out there who's receiving medical treatment and is out for an extended period, should we be running FMLA time at the same time that this person is out on workers' comp leave? Question number 6, should I totally delegate the handling of a workers' comp claim to the attorney handling my workers' comp litigation? Should I just periodically wait for those status reports and see what's going on with that case? Again, you can sort of get a gist of how we're going to answer that question, but that will be coming up. Number 7, question number 7, my injured employee's workers' compensation attorney says I have no right to communicate with him. A lot of times we deal with calls from our clients when we have overly aggressive plaintiff's attorney, and they issue a really angry letter to your HR manager or to you saying, absolutely do not communicate with my client. Everything goes through me. So we're going to talk about that you still have the right to follow your practices and procedures in communicating with your employees and requiring them to communicate with you despite the employee being out on workers' compensation leave and despite receiving sometimes an angry letter from the workers' comp attorney representing your employee. The final question we're going to look at is, can I discipline or fire an injured worker who is out on workers' compensation leave? Sometimes we receive calls where our clients think there's some kind of invisible comic book shield around someone who's out on workers' compensation leave, and that there's some extra special protection there where you can't discipline that person. And we're going to talk about how you can discipline and even fire in certain circumstances an injured worker who's out on workers' compensation leave and answer that question. Okay, so the one thing we want to really focus on today is when globally managing our employees who suffer any work-related injuries, an injury they suffer in the course and scope of employment, we have to look at not only the workers' compensation issues involved, whether we're going to pick up that injury, whether we're going to deny that injury, how we're going to manage that injury if we do pick it up, but also look at possible designation of Family and Medical Leave Act, and the tougher issue of dealing with the Americans with Disabilities Act issues. And as always, we're going to consistently follow our leave policies, have well-drafted leave policies, and if we're a union shop, we're going to follow and deal with our applicable collective bargaining agreement and any sections in that agreement dealing with light duty, leave, et cetera, et cetera. Okay, so first off, the easier issue before we get to the ADA is FMLA. Generally, any workers' comp injury resulting in lost time of 3 days or more that involves continuing treatment is a serious health condition under the FMLA. So it's hard to think of an example where an injured worker is out for more than 3 days or more and is getting continuing medical treatment and missing time, that doesn't fall under the definition of a serious health condition under the FMLA. as a general rule, you should always designate workers' compensation leave time as FMLA leave time. It's a very frustrating process if you have an injured worker out for 1 or 2 months, and then they come back from their workers' comp leave and they launch into an FMLA leave. So you always want to have that clock running on the FMLA leave while your injured worker is out on workers' compensation leave time. Now, the tougher question, we just went through the easy question of the FMLA, but the tougher question is your workers' compensation injury, the injury that your employee suffered, a disability under the ADA? It may be, it may not be. It's an individual case-by-case basis where your HR professionals, whoever you have in charge of reviewing this at your place of employment, has to drill down on a case-by-case basis and take a look at the medical evidence you receive, whether it's an independent medical examination or whether it's the medical documents or reports that the injured workers supplying to you and or to your insurance company or third-party administrator or your insurance adjuster. You have to look at those medical documents and sometimes engage in a back and forth with the employee to determine whether we have a workers' comp disability that also is a disability under the ADA. And as we all know, the definition of disability under Social Security law or workers' compensation law is different than the definition in your state for what is a disability under workers' compensation. And most workers' compensation statutes across the U.S. are liberal statutes designed to give the injured worker the benefit of the doubt. And the injury standard is basically that you suffer a disabling injury that disables you from your job, the job you're performing pre-injury. And then the burden falls on the employer to offer light duty or show you can do some other work at the place of employment. So the disability, whether that workers' comp disability constitutes an ADA disability will depend on, again, the case-by-case analysis and the particular injury involved regarding the severity and the duration of the injury. Now, an easy example that we all could talk about for a workers' comp injury that would constitute a disability under the ADA would be if one of our employees suffered a fall and herniated 2 discs in their back and has chronic nerve pain and debilitating problems where their gait is thrown off and they have a hard time walking. There's a real easy example of a workers' comp injury that's a severe injury of substantial duration or maybe even permanent duration that would constitute a disability under the ADA. But we also have a lot of injuries that fall in sort of the twilight zone area where we don't know whether with appropriate treatment and appropriate physical therapy whether that employee is going to recover or is going to be able to come back. Or we have a case where we think the employee, based upon our independent medical examination performed by our insurance company doctor, has suffered a sprain or strain, and the employee's doctor is coming back and saying, no, it's more of a permanent nerve injury to an area of their back. So we can go back and forth on a complex analysis of whether we have a disability under the ADA. So a quick overview of the ADA. The ADA obviously prohibits employers from discriminating against qualified individuals with a disability with respect to hiring, firing, and other employment decisions. And as we know, as employers were required to make reasonable accommodations to the known physical or mental disabilities of a qualified individual, unless to do so would be an undue hardship to us as an employer, or would pose a direct threat to the health or safety of the employee or others in the workplace. Now, as we know, disability under the ADA means a physical or mental impairment that substantially limits one or more of the major life activities of an individual. And again, in workers' comp, we have physical and mental injuries. We have a lot of stress claims out there in today's workforce, psychiatric stress claims, in addition to your everyday physical injuries, your knees, your back, and you run the gamut of all the physical injuries that our employees suffered. So a physical or mental impairment that limits one or more major life activities, having a record of such impairment, or being regarded as having such an impairment. Now, again, as we know, the ADA protects any individual with a disability who, with or without a reasonable accommodation, can perform the essential functions of the employment position held or desired. And when we talk about essential functions in ADA or workers' comp, when we're dealing with injured workers, it's always important that we have really well-written job descriptions that set out the essential functions of our employees, especially when we're doing an ADA analysis, and also when we're sometimes offering light duty or other job duties to our employees who are out on workers' comp. Okay, now when we talk about the interaction between ADA and workers' compensation laws, there is a subspecialty in the plaintiff's bar, the plaintiff's workers' comp bar and employment bar, that focuses on and litigates employer mistakes in handling the crossover of ADA and workers' compensation issues. And we're going to talk about that today, of how these mistakes and how these crossovers do not occur so smoothly. These mistakes occur a lot. We see some of our clients, sometimes, I hate to say it, dropping the ball on this when they do too much outsourcing with their third-party administrators or their insurance companies, and they have a workers' comp adjuster receiving all the correspondence from the plaintiff's claimant's lawyer, workers' compensation attorney, and this lawyer may be writing to the adjuster and enclosing medical reports or saying in his letter requesting accommodations under the ADA, requesting light duty, informing the employer, or at least informing the adjuster that this employee can do light duty and has been cleared to do light duty. So we're going to drill down that a little bit further in one of our question and answer sessions on that topic. And as always, the ADA is a central focus of the EEOC, and the EEOC has been doing some active enforcement of maximum leave policies and drilling down on the issues we're going to talk about here today. Okay, so I'm going to turn it over to Alex, who's going to answer our first question, most often asked question.
Hi, everyone. So our first question takes us to the beginning of the employment relationship. Can I ask applicants about their workers' compensation injury histories so I can screen out candidates who do not have an established history of suing their former employers for workers' compensation? No, this question should no longer appear on your employment applications. And here is just one of the first examples of how ADA issues can crop into workers' compensation issues. Under the ADA, a question about a workers' compensation claim history is an impermissible pre-offer medical inquiry, and the EEOC treats these inquiries as unlawful. The EEOC guidance reiterates this point, and in some recent litigation by the EEOC has won some pretty hefty settlements, for instance, $2 million settlements for a class of more than 6,000 individuals who are allegedly harmed by a policy requiring disclosure of personal medical information. All right, so here are couple points to make here about medical exams and inquiries under the ADA and how this could crop up in requests for workers' compensation histories. So again, pre-offer, these are inquiries you should not be making. Post-offer, however, is your dividing line. You can ask certain disability-related questions as long as these questions are asked of all new hires in the same job category and the medical information obtained is confidential. Well, what do you do with this information once you ask it? I mean, one of the options is, do I revoke a job offer based on this information that I've received? Well, there are some hurdles here that you really need to think through before you pull the trigger, so to speak. The revocation must be based on criteria that's job-related, that's consistent with business necessity, and you're pretty certain that the applicant or the officer sufferee at this point, rather, is not a qualified individual with a disability. And again, the EEOC has really drilled down on pre or post-offer medical inquiries in some recent suits. For instance, one application asked a reason for leaving an applicant's most recent job. He wrote down medical, and during the interview, he was asked, well, what medical condition did you actually have that you wrote here? Even if an applicant voluntarily offers this information, you shouldn't be asking questions about it. So the ADA puts no limitations, mind you, on your ability to hire the best qualified applicants. And as an employer, you can figure out who those applicants are going to be by setting the job requirements, by having a detailed job description that sets out educational background, work experience, skills, professional certifications, and licenses. Sometimes your best qualified applicants will be qualified individuals with disabilities, people who can do the job and are qualified to do the essential functions of the job with or without reasonable accommodations. Where the ADA draws the line is to protect those individuals from refusals to hire because they are disabled. All right, let's go to our next question. All right, so question number 2 takes us to the end of the employment relationship, which is the resignation letter. The question is, we've had our workers' compensation lawyer obtained a signed resignation letter from our disabled employee when the workers' comp case settled. And let's say here that the employee in question is your worst employee ever, and you had previously told your workers' comp attorney, listen, settle the workers' comp claim, but throw in a couple extra dollars because we want to permanently get rid of this person. That lawyer tells you, no problem, I'll give him the extra dollars and I'll get a resignation letter. Resignation letters are not get-out-of-suit cards. They are not releases, and I'll take you through some points as to why. Resignation letters are strong facts. They can provide employers with a defense that someone intended to leave the job, but that defense can be defeated with the argument that I had to sign, I really needed the money, and I was really given no choice, no time to consider it. That was pretty much it. And usually, you know, resignation letters won't spell out if someone might have gotten a couple extra dollars to get that resignation letter. So your only real protection from lawsuits are employment releases. This next bullet list shows you claims that will be included in a definition of claims that are waived by a release. So you have your discrimination claims, your AEA, your FMLA lawsuits, wage and hour claims, retaliation claims, even grievances pursuant to a collective bargaining agreement, unemployment claims. Even if a settlement is signed by a workers' compensation judge and approved by that judge, an employment release is really the only way to resolve employment claims. That release will contain consideration that is separate and apart from any workers' compensation settlement. There is also very specific language that guarantees the release of all claims. I, for myself and my heirs, executors, administrators, assigns, agents, and beneficiaries, if any, do hereby agree and execute to be bound by this general release of claims. I waive, release, and forever discharge my employer of all claims. This language does not appear in your typical resignation letter. Also, for your employees who are over 40, there is the waiting period, a consideration period that the employee can review the terms of the offer of the release, and then even upon signing, that employee has a 7-day revocation period. There's also specific language in a general release of claims that will address a release not prohibiting an employee from being able to participate in an investigation conducted by the EEOC or to testify in an EEOC hearing, but the release will foreclose monetary recovery for that type of claim. Again, your resignation letter won't contain that. Okay, so the important takeaway here is that if you have a workers' compensation negotiation and a separation of employment negotiation occurring at the same time, the two sets of lawyers need to talk to one another. They shouldn't be working apart, they should work together. So typically the release should be signed, and if you have an employee who's over 40, your consideration and revocation periods ought to have run prior to the workers' compensation settlement hearing. And you also want to have the release consideration, which is something separate and apart from the workers' compensation consideration, negotiated prior to finalizing the workers' comp. Importantly, the labor and employment lawyer should be drafting the release. This is an important takeaway for this process.
Okay, I'm going to jump back in with question number 3, which deals with ADA accommodation requests. And the question is this: I don't have to worry as an employer about the ADA since my workers' compensation adjuster is handling this case, do I? The adjuster is corresponding back and forth with the workers' comp attorney representing my injured worker, and I've sort of outsourced this. I really don't have to worry about the ADA, do I? Well, yes, of course we do. We have to manage ADA reasonable accommodation issues and engage in the interactive process where appropriate, because that's what the law requires. Basic practice pointers are we cannot totally outsource this function. We have to have our HR professionals, whoever we designate to do this, review all workers' compensation medical reports, review all correspondence and letters from attorneys for ADA accommodation requests. I gave the example earlier of an employer outsourcing this function, and not to denigrate, there's some very good workers' comp adjusters and professionals at insurance companies, but their job is to deal with that and manage that workers' comp case and to settle that workers' comp case, hopefully. And they're always pushing you to take your employee back in light duty so they get that person off of the workers' compensation benefits. But they're not dealing with ADA issues. They're not trained in that, and they don't deal with that, and that's not their job. So our HR professionals internally have to monitor medical reports. And again, remember, medical reports and letters can qualify as ADA requests. And under the ADA, we do not need magical language to equal an accommodation request. It can be as simple as a letter saying, from a doctor saying, my patient, your injured worker, has been cleared to perform light duty, and I recommend that he return to a light duty desk job. That may constitute an accommodation request, or a letter from an attorney saying that and saying, and please see Dr. Jones' report, which is attached. It's not a defense in an ADA claim in federal court to say and turn to a jury or a judge and say, well, judge or jury, we fell down on our job because we referred that out to an adjuster and an insurance company. It is our job to monitor these issues and manage these issues. Okay, so what do we want to do here? We want to, obviously, as I've said, review all medical reports to make the initial determination if a workers' compensation injury could qualify as a disability under the ADA. And we talked about some examples already. That severe back injury, it's probably a disability under the ADA. That sprain or strain may not be a disability under the ADA, but it involves a case-by-case analysis of looking at the medical issues. We also want to communicate with our disabled employee on a regular basis in writing. We want to inform the employee and inform our employee that they must tell us of any improvement in their medical condition that enables them to perform his or her essential job duties with or without a reasonable accommodation. It's a good idea when someone goes out on workers' comp to send them an initial letter saying, we would like to have you return. We hope your medical treatment goes well, and at any time if your doctor clears you for any job duties, please let us know. So we're engaging, whether this is a disability or not, we're starting that interactive process back and forth, and we're communicating with our employee, and also to tell our employee if they want to request an accommodation or a light duty job that they should do so, and we will appropriately consider that. Also, we want to have an updated, well-written ADA policy, and we want to integrate our ADA analysis and our ADA policy hand in hand with our workers' compensation policy, claims and claims handling procedures. We want to have these two analysis or policies that work hand in hand together. We also want to understand the ADA and the ADA Amendments Act, and as we all know, the Amendments Act sort of expanded the definition of disability, removed the mitigating factors from the analysis of whether someone is disabled or not, and we always want to engage in the ADA interactive process. We want to err on the side of caution. If we think that this may be a disability under the ADA due to the duration or the severity or both of the injury, we want to engage in that back and forth with our employees regarding an interactive process. And we're going to talk a little bit later about maximum leave policies. We want to be careful about maximum leave policies. They should be carefully drafted to comply with the ADA and EEOC guidance. All right, so I said we're going to talk about maximum leave policies, and here it is. Question number 4, a maximum leave policy. As an employer, let's say we have a 1-year policy of terminating anyone who's unavailable for work after 1 year. If you're out for a year, you're gone. We apply it consistently. We apply it across the board. So does this eliminate all potential liability under the ADA? Does it? No. No, it does not. A maximum leave policy must be carefully drafted to avoid ADA liability, and let's drill down on how we can carefully draft this policy. So basically, I mean, the basic fact of a maximum leave policy, the old days are over. Again, I'm the grayer-haired member of this panel. I remember not only when you could ask people on an application years ago in the Stone Ages about workers' comp injuries, but I also remember prior to the ADA, that a lot of us had, as employers, we had strict policies. If you're out 6 months, you're gone. If you're out 8 months, you're gone. Under the ADA, you cannot have a per se limit, a per se inflexible limit saying 6 months is it, or 8 months is it, or a year is it. Any maximum leave policy must involve a flexible back and forth with the injured worker to determine if the injured employee can return to work in the foreseeable future. Again, it can't be absolute. It has to be a back and forth policy with some flexibility. And again, under the ADA, offering leave time to employees who have a disability under the ADA is in and of itself a reasonable accommodation, absent undue hardship. The EEOC recognizes that additional leave time beyond the amount of leave time that an employer normally grants or provides must be considered as part of the interactive dialogue before terminating an employee. So as a result, since the EEOC says that we can't have an inflexible set time. We have to, on a case-by-case basis, examine whether someone is able to come back with an extra month or 2 of leave, or whether it's an extra couple months. We cannot have a per se policy. There has to be some flexibility in evaluating these issues, and let's drill down as to how we can do this. Now, unfortunately, as we've stated, there is no uniform magical rule. There isn't a finish line here where we say if you go a year and 2 months, that's enough time. There is no set time period. The interactive process is an individual case-by-case analysis, and you have to conduct the interactive process to determine what leave would be a reasonable accommodation, whether an extension of your leave policy is a reasonable accommodation and should be called for in each individual case. Now, leave as a reasonable accommodation does not mean it has to be paid leave, but use of accrued paid leave is a reasonable accommodation. And as always, as employers, we should consider other less restrictive accommodations such as reassignment, reduced hours, or an assistance device. And you always want to review your workers' compensation medical records and your testimony in workers' comp cases as part of your interactive process to see what that employee is saying about their ability to come back to work or inability to come back to work. Because sometimes we get inconsistent claims. They may be asking us for return to work or a light duty position, but they go to comp court and they testify that they're paralyzed with pain and they have a permanent injury and they can never go back to work. So you always want to look at everything. You want to look at the medical reports and what's going on in workers' comp court regarding testimony. Okay, so many courts have rejected. Now, on the opposite extreme, do you have to give indefinite leave? No, you do not. Indefinite leave has been rejected by many courts as a reasonable accommodation. Most U.S. Circuit Courts of Appeals have held that indefinite leave is not a reasonable accommodation. So employers do not have to give indefinite leave. That would be inherently unreasonable. The Third Circuit and Pennsylvania federal courts have consistently held that indefinite leave is not a reasonable accommodation. And even the EEOC concedes that employers have no obligation to provide leave of indefinite duration. Granting indefinite leave can impose an undue hardship on an employer's operations. We're operating businesses. We're producing products. We have to have people that do our job functions, and indefinite leave means that we have an unfilled spot that's not getting the job done. Okay, so even if an employee can't provide a fixed date to return to work, requested additional leave still may constitute reasonable accommodations unless we have an undue hardship. Now, where leave is granted without a fixed return to work date, the employer should require the employee to provide periodic updates on their condition, and the return to work may, and we should evaluate whether the continued leave is an undue hardship. So let's look at what we would say is a recommended leave policy language, a maximum leave policy that has the flexibility we've talked about. So here's some recommended, and when I say recommended language, I don't think you should copy this language and draft a maximum leave policy here today. I would recommend you give us a call, because these policies are a little bit complicated. They depend on your workforce, your particular circumstances. But here's an example in general. To provide employees with enough time to seek medical treatment and to recover to the point that they can return to work if possible, employees absent for work for medical reasons may remain out on approved leave based on the employer's policy for blank months. Let's say you have 12 months, subject to the case review procedures set out below. Now, when we say case review procedures, you'll see that they have flexibility involved. Subject to the case review procedures set out below, the employee will separate from employment at the end of the 12-month period. I'm just filling in 12 months. You can decide when you consult with your labor attorney how long you want to have this policy run. So here's the case review process. The employer recognizes that there are cases in which an employee may exhaust let's say it's 12 months of approved medical leave, but could return to work and perform the essential functions of his or her job with a reasonable accommodation, including an extension of the 12-month period. For this reason, the employer will initiate a case review of any employee on medical leave before separation from employment occurs. This case review will be initiated within 90 days of the expiration of the 12-month leave period. So the case review will involve the employee being contacted in writing to address the following issues: whether the employee is a qualified individual with a disability, whether the employee can resume his essential job functions in the foreseeable future, if granted additional leave beyond the 12-month leave period. Now, an easy example of that is you have a 12-month policy, but you get a letter from the workers' compensation attorney on the 11th month saying, well, John Jones, and I have a doctor's report attached from Dr. Smith, John Jones needs another month and a half of rehab, of intensive physical therapy treatment, and after that, his treating physician says he can come back. There would be an example of extending that leave period. Now, also, you want to ask the employee whether alternative reasonable accommodations are available and whether any such accommodations you want to examine whether alternative reasonable accommodations are available and whether any such accommodations pose an undue hardship on the employer. So that's the basic flexibility we're talking about. All right, I'm going to turn over and we can drill down further on some of the maximum leave issues, but I'm going to turn over next to Erin, who's going to address FMLA designation.
Hi, Hi, everyone. We're on to question 5 right now, which is the claimant is out on workers' compensation leave, so I can't designate this leave as FMLA leave. Can I? Yes. The best practice in this circumstance is to designate all workers' comp leave as FMLA leave where possible. And as Pat mentioned earlier, in most cases of workers' compensation leave, the employee will fall under the FMLA as well. This issue is frequently asked of us when an employee has been out on workers' compensation leave, but that leave was not designated as FMLA leave. An IME may come in and the employer offers a light duty position, but the person declines, but later requests FMLA leave. So in that circumstance, if the employee is entitled to FMLA leave, then they must be granted that 12 weeks, even if that leave would exceed the maximum leave policy that Pat just mentioned. And the employee cannot be terminated until that 12 weeks expires. So it's best to designate all workers' comp leave as FMLA leave.
If they want to answer questions.
We're on to question 6 right now. Okay. This question asks, my workers' comp attorney is handling this. Can't I just wait for a copy of the judge's decision? No. Employers should globally manage all injury claims and be involved with the workers' compensation case as it's proceeding. It's very important for employers to communicate with their workers' compensation counsel during pending cases. On slide 35, we have a list of the essential policies that workers' compensation attorneys should review and have an understanding of when defending a workers' compensation case. And it's important that the attorney is familiar with these and knows how these policies may impact the outcome in the case. So if, for example, the employer is unionized, the collective bargaining agreement may have rights or limitations in it that may affect whether the employee can return to work or whether they can return on light duty. There may also be pension implications, the workers' comp policies and procedures. The attorney should have an understanding of the employee's obligations under those policies, as well as ADA policies and drug testing issues. Next slide. So it's also important to educate your attorneys on what actually practically happens in the workplace. Workers' compensation attorneys should visit the workplace and have an understanding of how it operates, what employees actually do. And as we discussed earlier, Labor and Employment Council should work with workers' compensation attorneys because there may be crossover between the workers' compensation claim and a court case or a grievance or an EEOC charge. So they should work hand in hand to develop a coherent strategy to obtain the best results for the employer. They shouldn't work in isolation. And as we discussed earlier, in the case where a workers' compensation case may settle, but the employer doesn't want the employee to come back to work, it's important for both counsel to work together so that they can obtain a release. Now we're on to question 7, which asks, when my employee is represented by a workers' compensation attorney, can I talk to the employee? Yes, injured workers still have to comply with your employment policies and communicate with their employers. The workers' compensation process doesn't shield an employee from talking to the employer, and this often comes up when there's an overly aggressive workers' compensation attorney who threatens the employer that they cannot talk to the employee. You can have labor counsel step in to resolve that, but it's important to remember that the employee is still required to comply with all policies. So if your workers' compensation policy requires the employee to periodically report about their condition and about their ability to return to work, they must do so. You can have the employee come into work. So a workers' compensation claim or an attorney saying that you can't talk to them doesn't shield the employee from communicating with their employer.
I'm going to jump in for our final I'm going to jump in for our final question, which is, can an employer discipline or fire an injured worker who is out on workers' compensation leave? As most of us know, the answer is yes, as long as the discipline or firing is for legitimate, non-discriminatory reasons. I've had clients over the years, again, somehow think that since someone is out on workers' comp injury leave, that they have some kind of shield against them, and we can't take disciplinary action against them while they're out on workers' comp leave. But that's not true. Now, many states have retaliation laws, workers' compensation retaliation laws. And for example, in Pennsylvania, employees can sue under Pennsylvania law for terminations that occur in retaliation for the employer filing a workers' compensation claim. But remember what that is. That's where someone's suing saying, I was only terminated because I filed a workers' compensation claim. If the employer can show a non-discriminatory, non-retaliatory reason for discipline or termination, then that workers' comp retaliation claim would be baseless. Like any other employee, we should investigate any of our employees that are on workers' compensation leave. If we receive evidence that they've committed a disciplinary infraction, we should as employers, we should appropriately investigate that and take appropriate disciplinary action. An example, an easy example is you have an individual out on workers' compensation leave. They were hurt 3 months ago. Let's say they have a legitimate back injury. While they're out, you discover they've been embezzling company monies. Now, obviously, that's a crime, and that's a disciplinary offense. So you turn it over to the local DA and you fire this person. That's totally justified. You're not firing them because they have a work-related back disability. You're firing them because they committed a crime and they stole from you. So you still can discipline someone when they're out on workers' comp as long as you show that it's for a legitimate, non-discriminatory or non-retaliatory reason. So let's go, and if we have time, we'll take a couple questions after we finish, but let's go through sort of our wrap-up and our recommendations here in general about globally handling workers' compensation claims. Okay, so what have we learned or what do we recommend here today? The first thing is you want to avoid tunnel vision. We've thrown a lot at you here today, workers' comp laws, ADA, FMLA, workers' comp retaliation, but you always want to look at this in a global setting, and you can't outsource this. You can work hand in hand with your insurance company, your third-party administrator, your workers' comp attorney, your labor attorney, but you have to have somebody at the workplace quarterbacking this. You have to have an HR professional or someone who's quarterbacking this, looking at the medical reports, looking at the letters that come in, speaking to your workers' comp attorney, educating the workers' comp attorney on what they should know about your workplace and your policies, and dealing appropriately when they should with labor counsel in maybe wrapping all this stuff up. And also, sometimes we have conflicts with our insurance company. Sometimes our insurance companies and third-party administrators just want to settle that comp case, and they want us to take this employee back who maybe we don't want to take back because they're someone who's been a real disciplinary problem, and we're saying, well, maybe this is a time if a comp case is going to be settled, maybe we can reach a settlement of everything. We could have a workers' comp settlement and a labor and employment release at the same time for a little bit extra money, so this person goes away. They sign releases and they go away, and let's say this person has a lot of grievances or other issues out there. They resolve all that through a settlement in comp court and in the workers' compensation forum. Okay, so, and what we also recommend is have a system at your workplace, have sort of a flow chart, and this is, again, this is a general example, and we'd be glad to work with you in detail on this, but have a flow chart for how you handle these issues. Start off by requiring all injured workers to fill out an injury form, require all employees to list all their treating medical providers and sign a medical release when they're treating for a workers' compensation injury, require all employees to provide medical documentation of any claimed injuries, require your employees to attend a medical examination with a doctor chosen by the employer and to treat with the employer's posted physicians. Many states have requirements that if an employer posts a list of physicians that the employees have to go to those physicians for a certain time period after the injuries. That's 90-day in PA. So you want to take advantage of some of the favorable things in workers' compensation laws in your state, and you want to make sure you follow the favorable aspects of those laws. Obviously, we want to investigate all injury claims. We all hear about workers' compensation fraud. We all hear about people exaggerating injuries. Well, it does happen out there. So we want to appropriately investigate all injuries as they happen. We want to interview all witnesses and take witness statements. We want to obtain all relevant documents, such as accident reports, if we have an employee suffering a work-related car accident. If we have a drug testing policy, there may be cases where we want to drug test, where we think there may have been drugs or alcohol involved with this incident. And we only want to issue a decision accepting or denying an injury claim after we've taken the appropriate investigatory steps. And we don't want to outsource that decision either, too. We're an insurance company just making that decision. We want to work hand in hand with, we're paying good money for our insurances, and we want to work hand in hand with insurance adjusters or third-party administrators in making these decisions. One of the lessons we want to have, or lessons we learned or want to have on our flow chart is we want to designate all time that someone's out on a work-related injury as FMLA leave time, and want to have the FMLA leave clock ticking at the same time we have someone out on work-related injury leave. We also want to examine and draft a consistent light-duty policy that complies with the ADA and your workers' compensation laws in your state. We want to maintain a consistent leave policy that complies with the ADA and the FMLA. We want to monitor medical reports and communications from the injured worker and or their attorney to ascertain whether we have an ADA situation and whether we should engage in the reasonable accommodation process and whether accommodations have been requested. We want to appropriately consider, review, and communicate with the employee regarding any accommodation requests and again, engage in that interactive process. And then finally, or close to finally, we want to draft an ADA-compliant maximum leave policy, which we hear today is a little bit of a complex process, but it can be done. It can be done. It's a process that should be done. Okay, and then the other lesson we learned today is when you're trying to settle a here's the last thing you want to happen. You don't want to have a third-party administrator or an insurance company throwing $80,000, $100,000, $120,000, $120,000 at someone to settle a workers' compensation case without consulting with you as the employer about whether you want, number one, to settle that case, number two, to maybe wrap up all issues involved with this employee at the same time. Because a lot of times when a plaintiff's attorney involving in workers' comp is out there, if you start early getting global discussions going and saying, okay, Mr. Claimant's attorney, if we settle this case, it's going to involve not only filling out the appropriate settlement documents in workers' comp court, your client's going to have to sign an employment release, and we'll throw another X dollars on that. If you start that early, usually you don't have to throw a lot of extra dollars on that employment release because the attorney and the injured worker understand that this is part of the process. So you want to avoid what's called the Lazarus syndrome. It's something that we used to talk about in the disability field of someone would settle a workers' compensation case for $100,000, and the next day, and they would have all these medicals saying they have chronic nerve pain, totally debilitated. The next day they'd be knocking on your door at the place of employment saying, hey, I'm ready to come back. And the employer would call us in a panic, and we're like, oh, I wish they had called earlier, and we had worked out a joint a separate labor and employment release for resolving those issues. So again, if you should think about a global resolution of all claims, and that involves, as we discussed earlier, that involves two separate releases: the appropriate release and settlement in workers' compensation court, and then a separate labor and employment release with separate consideration. So that is how you globally resolve claims. So in conclusion here today, we recommend strongly that everyone drafts and updates their ADA, workers' compensation, FMLA, and maximum leave policies and procedures. And again, these all work together. So taking a look at all of them and how they flow or interact together. As always, investigate all of your workers' compensation claims and look at these claims globally in light of the FMLA, the ADA, and all workers' compensation issues concurrently. And then when we are settling, let's possibly try to settle everything at the same time. That's the time to wrap up all these troublesome issues. Now, we have a couple minutes. We could answer a couple of the questions that are popping up on screen here. If everyone wants to hang on, one of the questions we received is, it states, okay, the first question we received is, should an employment release be signed every time someone resigns?
It's Alex. I'll jump in. I think that really depends on the employee involved. I mean, a release, in order for a release to be effective, one of its foundations is adequate consideration. So do you want to be giving money to every employee every time an employee walks out the door? You may not feel like you need to insulate yourself from the risk of a lawsuit. That may only be in the case of an employee who has outstanding grievances or has had disciplinary issues, and you want to make sure that with that employee walking out the door, you have tied everything up. You have secured a release in exchange for consideration, and that release would cover included waivable claims up to, relating to the employment, up to and including when the release was signed.
I agree with Alex. It's a case-by-case analysis, and we all have really good employees who suffer injuries and are not coming back sometimes, and they may resign and settle their workers' compensation case, and we may not have any real concerns about worrying about all these other issues. But again, the only way to wrap up the employment issues is through an employment release. So if you have that really troublesome employee who's been out there with all kind of grievances, claims, problems, disciplines, you probably want to get that release at the same time. And again, the only way to protect yourself from number one, the employee settling the case and trying to come back, or the employee settling the case, settling the workers' comp case and then suing you for various other legal claims, is to get that release. So no, you don't have it in all cases, but you on a case-by-case basis, to err on the side of caution to eliminate liability, yes, you should get one. Okay, here's a question. How long is too long? How many times should you extend leave? Is there a max for extension? Okay, I wish we had a miracle answer on this. How long is too long? I don't know, but I'll just tell you this: it's supposed to be a reasonableness standard. If you're engaging in a back and forth with the employee, and let's say you have a year policy, and you have that flexible maximum leave policy we talked about, and this person's getting close to the year, you write to them, you examine the medical records, you look at their workers' comp testimony, and you write to them and say, is there any chance you're going to be able to come back in the foreseeable future? Please provide us with medical documentation. The easy cases, they don't. And in comp court, they're testifying about permanent pain and permanent disabilities, and their doctors are talking about they've reached maximum medical improvement and it's a severe lifelong problem. There's an easier case where they're not really, right. They're pretty much setting it up saying they can't come back. Let's do another example. You extended, they say they need additional physical therapy, their doctor, or they're going to get surgery, and their doctor thinks after the recovery period on this surgery, they may be able to come back. And as we know, when you get surgery and you have a recovery period, that takes a substantial amount of time. And say you give a year and 6 months, and then you're writing back and saying, we need an update on how this surgery went. At that point, if they can't give you any foreseeable return to work, is that the magic line? Is that too long? I can't say definitively, but you would look like you really bent over backwards there, and you look like you're being really reasonable.
Right. I mean, even the undue burden analysis, which is, one defense that an employer has to cut this off. This employee is a key employee for this group and does this function, and we haven't been able to find someone exactly quite right to replace this person while this person's been out, and it's costing us this many dollars and this many cents to have this person to be out. I mean, even that analysis is a case-by-case analysis, and there won't be a simple answer. And there will always be a little bit of a question: have we given this employee enough? Have we done right? Is it really true, in fact, that we can't continue to function this unit because this person's out? There will always be a little bit of a question mark, but at some point you get your ducks in a row and you should pull the trigger.
Okay, the next question says, if an employee is on workers' comp and the employer offered light duty to accommodate this employee and the employee denied the light or refused the light duty request, it also says in this question that the employee was sent FMLA paperwork and never returned the paperwork. Can I terminate employment? Well, this question's hard to answer in this format. If you offer light duty to an employee and the employee refuses that light duty, they could be refusing the light duty because they have a medical report from their doctor saying that they can't perform the light duty. That's different than them just ignoring it or just flat out saying, I'm not coming in. You could possibly terminate depending on what exactly is going on here. If this is a year out and you've been communicating back and forth and this person has no foreseeable return and you've offered them light duty and they write back, they provide you medical documentation from their doctor saying not only can they not do that light duty, but they think they have permanent restrictions and you can't accommodate those restrictions, then I would suggest another letter there saying that we're going to possibly terminate on this date unless we receive more additional information about any foreseeable return to work, and it appears from your doctor's medical information that you can. So possibly you could terminate here, but I think we'd have to fill in a little more holes. And there's something here about not returning FMLA paperwork. I would conditionally designate if someone's out on workers' comp, and even if they don't return FMLA paperwork, because I want that time to run.
Right, right. I mean, I think the answer to this question depends on the level of communication, and I wouldn't feel comfortable just sitting back just because someone hasn't responded. It may take another letter from you, or if someone, for instance, flat out and says, no, light duty won't work, well, then there's the follow-up question. Well, do you have any ideas of what might work, or has your doctor suggested anything that could possibly work that would enable you to come back and perform the essential functions of the job?
Okay, we're just going to do one or two more, and I think we have to close off in a minute or two. We have a question here. It says, if a worker out on workers' compensation leave is behind on their health insurance premiums, when can you remove them from the insurance coverage? Well, workers' comp laws have no jurisdiction over what your employment policies on people paying their premiums or their co-pays or for health coverage. So when someone's out on workers' compensation leave and they're still receiving your health benefits and they have to pay a premium for that, you still follow your policy on that. I would still send them the appropriate letters saying you're 2 months behind in your premiums. As you know, our policy is after 3 months, you're cut off. We're talking about health coverage here. Under workers' comp, if someone's out on a workers' comp injury, they receive under the workers' compensation law, you're responsible for their medical bills related to their work-related injury treatment, but their health insurance benefits that you're still providing, that depends on your internal policies on what they're required to pay premiums and when you cut off benefits when they're not paying their premiums. So I still would follow your normal practice, your policies and practices regarding that. There's one final question. Maybe we'll close off with this. It says, what happens when an employee out on workers' compensation injury exhausts the 12 weeks of FMLA, but they still can't return to work? What do we do? Well, we just went we went through that. If we can just reemphasize this, if someone's out on a workers' compensation injury and they've exhausted the 12 weeks of job protection in the FMLA, that does not mean you can fire them. You have to go through that whole maximum leave analysis, and if you don't have a policy that deals with that, that's something you really should consult with your labor attorney on, because you have to globally look at this. It's not as easy as saying, hey, the 12 weeks of FMLA job protection are done, so therefore I can fire this injured worker. That's something you cannot do. You have to go through the nuanced analysis that we've discussed here today. I want to thank everyone for joining us here today. If you have any follow-up questions regarding what we've talked about today, feel free to contact any of us via email or phone. We'd be glad to help you out with any of these questions, and thank you.
Yeah, and we received a number of questions that we weren't able to address on air right now. We'll do our best to shoot you responses individually. Thanks, everyone.